To be or not to be a manifestation? That is the question. Disability Rights Florida, presentations by Ann Siegel and Natalie Alvarez. Your presenters. Hello, I'm Ann Siegel. I'm the legal director at Disability Rights Florida. I've been an advocate for children for over 26 years. I received my Juris Doctor from Nova Southeastern University Shepherd Broad Law Center. I was a Disability Law Fellow at the Children First organization and volunteered as a guardian ad litem. For 15 years, I served as a surrogate parent for children in the dependency system within Broward County. I gained substantial legal experience working as a staff attorney in the Education Legal Rights Project of the Children's Advocacy Program at Legal Aid Service of Broward. My first job out of law school was with the Advocacy Center for Persons with Disabilities, and then in January 2009, I returned to Disability Rights Florida, which was formerly the Advocacy Center. I'm the legal director at Disability Rights Florida, and I'm a Florida Bar member admitted to practice in the U.S. District Court of Southern, Middle, and Northern Districts, as well as the 11th Circuit Court of Appeal.
Hello, and thank you for joining us today. My name is Natalie Alvarez, and I graduated from Florida State University and earned a Bachelor's of Science in Psychology degree in August of 2012. I joined Disability Rights Florida in July of 2013 as an advocacy specialist on the intake team. In June of 2015, I became an advocate investigator at Disability Rights Florida on the Advocacy Education Outreach team, and my work focuses on special education cases, specifically on the development and implementation of IEP plans, which is also considered individualized education plans, with an emphasis on individuals with behavioral challenges and disciplinary issues. Disability Rights Florida. We are Florida's protection and advocacy agency with funding and authority under 9 federal programs. We are a not-for-profit corporation since 1987. We provide free and confidential services, which is information and referral, advocacy, legal representation and negotiation, as well as investigations and facility monitoring, access to education, employment and independence, elimination of abuse and neglect. We have offices throughout the state, including our main office in Tallahassee, Hollywood, Florida, Tampa, Florida, Gainesville, Florida, and satellite offices throughout the state. Our agency's mission is Disability Rights Florida advocates, educates, investigates, and litigates to protect and advance the rights, dignity, equal opportunities, self-determination, and choices for all people with disabilities. Topics we will cover are: what is a manifestation determination review, also known as MDR, how to prepare for an MDR, what constitutes a change of placement, what are the legal requirements, and how to obtain behavioral supports for your child. What is a manifestation determination review? A manifestation determination review is when a student with a disability has been either suspended for a cumulative of 11 or more days within 1 school year, or the school is proposing a change of placement before the suspension exceeds 10 days. A MDR must occur within 10 school days of any decision to change the student's placement with a disability because of a violation of a student code of student conduct, such as a suspension. A MDR includes the parent, the local educational agency, also known as an LEA, and relevant members of the IEP team. The supporting legal requirement can be found in 34 CFR State Statute 300.523, Section A. At a manifestation determination review meeting or at an MDR meeting, the team must review the behavior in question and shall review all relevant information in the student's file, including the child's individualized education plan or IEP, any teacher observations, and any relevant information provided by the parent to determine the following 2 questions. The first question is, if the conduct in question was caused by or had a direct substantial relationship to the child's disability. And 2, if the conduct in question was the direct result of the LEA or local educational agency's failure to implement the IEP. Now, if the team answers yes to either of those questions, then the conduct shall be determined to be a manifestation of the child's disability. To clarify, there only needs to be a yes answer to one of the two questions. As long as the team answers yes to either the first question, that it was a direct and substantial relationship to the child's disability, or if they only answer yes to it was a direct result of the local educational agency's failure to implement the IEP, then that behavior is found to be a manifestation of the student's disability. Okay, and remember, this is a team decision, so all team members must voice and have input on the decision made. Once a determination has been made that the behavior in question is a manifestation, the IEP team shall 1. Conduct a functional behavioral assessment, also known as an FBA, and implement a behavioral intervention plan, also known as a BIP or PBIP for Positive Behavior Intervention Plan, for such child, provided that one had not conducted such assessment prior to such determination before the behavior that resulted in a change of placement. 2. In the situation where a behavioral intervention plan has been developed, review the BIP if the child already has one and modify it as necessary to address the behavioral needs of the child. 3. Return the child to the placement from which the child was removed unless the parent and team agrees to a change of placement as part of the modification of the behavioral intervention plan. So in essence, even if the child was given a 10-day suspension, as mentioned before, the manifestation determination review meeting has to happen within 10 days of the incident itself or the behavior and from the suspension. So if the student was given a 10-day suspension, the team comes together for an MDR meeting on the 4th day of suspension, and the team determines that this is a manifestation of the student's disability, then the student does not have to complete the full 10-day suspension. They are to immediately return back to their last agreed upon placement, wherever they were previously at the time of suspension. How to prepare for an MDR. To prepare for an MDR, you will want to review all of your child's educational records, including their IEP, evaluation reports, and disciplinary records. Keep records of your child's disciplinary history throughout the school year, reasons for suspensions, and number of days suspended. Know your child and what their behavior looks like when it is manifesting. Be familiar with all of the behavioral supports and services outlined in the child's IEP and their BIP if they have one. Do not hesitate to contact the school to request a MDR meeting should you know that they have exceeded 10 days of cumulative suspensions for the school year if the school year has not scheduled an MDR meeting. And remember, an MDR must be conducted within 10 days.
What constitutes a change of placement? What constitutes a change of placement? Continuous suspensions beyond 11 days where a child is constantly removed from their educational environment and services. A school changes or recommends changing the child's placement to either a different setting or school as a result of a suspension prior to a student being suspended for more than 10 days. Please note, the use of threat assessment cannot be used to circumvent or take place of the manifestation determination review process. Only an individual education plan team can determine the appropriate placement for a student with an individual education plan. Special circumstances, also known as the 45-day rule. School personnel may remove a student to an interim alternative education setting, IAES, for not more than 45 school days without regard to whether the behavior is determined to be a manifestation of the child's disability. In cases where a child 1. Carries or possesses a weapon to or at school, on school premises, or 2. A school function under the jurisdiction of state or local educational agency. 2. Knowingly possesses or uses illegal drugs, or sells or solicits the sale of controlled substance while at school, on school premises, or at a school function under the jurisdiction of state or local educational agency. 3, has inflicted serious bodily injury upon another person while at a school, on school premises, or at a school function under the jurisdiction of a state or local educational agency. The definition of serious bodily harm. According to Section 1365, paren H, paren 3 of Title 18 U.S.C., serious bodily harm is defined as bodily injury which involves A, a substantial risk of death, B, extreme physical pain, C, protracted and obvious disfigurement, or D, protracted loss of impairment of a function of a bodily member, organ, or mental faculty. Scenario 1, suspension. Timothy is a third grader who had an outburst at school. He bit and kicked the school principal. He was suspended and unilaterally removed to an interim alternative education setting because he allegedly violated the student code of conduct by physically sticking others, including the principal, while having an outburst. The district notified the parent that special circumstances justified removing the student to the IAES. The district contended that because the student inflicted serious bodily injury upon the principal during the altercation, they could remove the student without conducting a manifestation determination. The parents appealed the decision. Was the district correct? Answer. The hearing officer explained that while the existence of special circumstances can justify removal to an IAES for up to 45 days, regardless if the student's conduct was a manifestation of a disability, but none of the applicable circumstances were present in this case. The behavior or action in question does not meet the standard definition of serious bodily harm, as the district originally considered. The manifestation issue was moot because the district did not make a determination within the required 10 school days. Instead, they changed his placement. The hearing officer cautioned that such determination is still necessary even in cases where the district opts to remove the student due to infliction of serious bodily harm or other special circumstance. The district was required to convene an individual education plan meeting for the purposes of determining if placement at an IAES is warranted or if further supports and services are necessary to meet the child's needs. What are the legal requirements? Now we're going to address a few legal authorities. Legal requirements 1 of 5. Section 504 of the Rehabilitation Act of 1973, 29 U.S.C. Section 701, prohibits discrimination based on disability. Section 504 is an anti-discrimination civil rights statute that requires the needs of students with disabilities to be met as adequately as the needs of the non-disabled are met. Section 504 covers students with disabilities in public schools. A 504 plan may include accommodations that address how a student learns the materials. Related services may include transportation, behavior intervention plan, or other supportive services as required to assist a child with a disability to have access to a free, appropriate public education, FAPE. Legal requirement 2 of 5. Individuals with Disabilities Education Act, IDEA, 20 U.S.C. Section 1400. A law in place to ensure that all children with disabilities have available to them a free, appropriate public education, FAPE, that emphasizes special education and related services designed to meet the unique needs and prepare them for further education, employment, and independent living. The IDEA governs how states and public agencies provide early intervention, special education, and related services to more than 6.5 million eligible infants, toddlers, children, and youth with disabilities. Legal Requirement 3 of 5, the Individualized Education Plan, IEP, a plan that is made to address each child's unique needs. An IEP includes a present level of performance, PLOP, annual educational goals that must be measurable, special education supports and services, related services, modifications and accommodations for in-class and standardized tests, transition planning. Legal Requirement 4 of 5. Senate Bill 7026, Chapter 2018-3 Laws of Florida, Public Safety Act, also known as the Marjorie Stoneman Douglas High School Public Safety Act, authorizing the awarding of grants through the Crime Stoppers Trust Fund for Student Crime Watch programs, establishing the Office of Safe Schools within the Department of Education, comprehensively addresses gun violence on school campuses. The law promotes school safety and enhanced coordination between education and law enforcement entities at a state and local level. And our last legal requirement, 5 of 5. Senate Bill 9 amends 394.495 of the Florida Statutes Child and Adolescent Mental Health System of Care Program and Services to require contracted community action treatment teams to provide community-based behavioral health and support services in 22 counties, regions, or more subject to appropriations. Senate Bill 726, Section 29 revises 1011.62 Florida Statute, Funds for Operations of Schools 2. At least 90% of district allocation must be spent to provide mental health assessment, diagnosis, intervention, treatment, and recovery services to students with one or more mental health or co-occurring substance abuse diagnosis and to students at high risk of such diagnosis, and to coordinate such services with the student's primary care provider and the student's other mental health providers.
How to obtain behavioral supports for your child. Behavioral challenges are prevalent in students with an array of disabilities such as autism spectrum disorder, or ASD, attention deficit hyperactivity disorder, or ADHD, intellectual disability, or ID, specific learning disabilities, SLD, etc. Characteristics that may contribute to behaviors are communication barriers, learning difficulties, impulsivity control, and sensory issues. In the case of a child whose behavior impedes a child's learning or that of others, the IEP team must consider the use of positive behavior interventions and supports and other strategies to address that behavior. That information can be further explored under 20 USC 1415 Section D3BI and 34 CFR 300.324 Sections A to I. Once you and the team have identified that the child has behaviors that are impeding the student's ability to gain educational benefit, it is time to think about behavioral supports and services. Some steps to take to obtain behavioral supports and services for your child in school can be requesting a meeting in writing to meet with your child's IEP or 504 team. At the meeting, review and consider any and all anecdotal behavioral data such as referrals, suspensions, teacher input, or any other data available at the time. Request evaluations such as a functional behavioral assessment or an FBA, psychological and psychiatric evaluations, or any other evaluations that the team deems necessary at that given time. And remember that each child needs to make meaningful academic progress and learn socially appropriate behaviors and coping skills. As mentioned, functional behavioral assessments are utilized to explore and understand the behavioral needs of a student and need to be data-based and include information based on a review of records, referrals, discipline reports, and comprise of a series of observations in various settings or in the setting of concern. Please note that functional behavioral assessments should be conducted in the environment in which the student needs to receive the supports and services. The functional behavioral assessment should observe and gather data that should be able to provide What is the function of the behavior? Where and when does it occur? And what is the antecedent to the behavior? Behavior is often a form of communication, especially with children who are either nonverbal, may have limited verbal output, or even have pragmatic language deficits. An FBA must include the following components: identify and describe the target behavior, indirect assessment review of events, environmental factors, direct assessment observation and recording of data, data analysis, strength of the student, reinforcement determination, and hypothesis development. Strategies for effectively addressing behavioral problems that are proactive, educative, and functional in nature. The PBIP, or Positive Behavior Intervention Plan, addresses behavior that is a negative pattern and impedes the student's learning. The PBIP should be based on recent and meaningful assessment data, such as an FBA, and is individualized for the student. A PBIP needs to address the target behaviors, needs to be based on data, must be realistic, it needs to be positive and not punitive in nature. The team should consider the child's past trauma when developing the plan. If it isn't working, it needs to be readdressed. All staff working and in contact with the student need to be trained on the plan. You need to have the student's buy-in. The parent, guardian, caregiver should assist in developing the plan to ensure it is carried out across all settings. This is extremely important to remember when you as a team are developing the plan, because continuity of the plan being delivered is most beneficial for the student, especially when the parent is aware of what strategies and interventions are being provided in school. Those can also be provided in the home, and it must be delivered with fidelity. Components that must be included in the PBIP should be positive interventions, natural consequences, not focus on negative consequences or punishments. Examples of that could be timeout or removing a reward once a student has already gained the reward. Teaches appropriate replacement behaviors based on data from a comprehensive FBA, plan for training all staff that work with the child, plan for monitoring and collection of data. This is extremely important because the data over time will be a really good indicator to the team whether or not the positive behavior intervention plan and the interventions that are being implemented with the student and the taught replacement behaviors, are they successful with extinguishing the problem behavior and increasing the desired behaviors, and incorporates the school and family's concern. There are other supports and services that can be obtained through the school that would support a student who is having problem behaviors, and some of them are school-based counseling services that can address and teach the de-escalation and coping skills within the school environment, mental health services that can be provided by the district with funding through Senate Bill 7026 to serve a child that has been identified as a child at risk, or if there is an underlying mental health diagnosis that the team feels it's contributing to the behaviors that services are necessary to address. If the student should have significant behavioral concerns that put the student's safety at risk, such as self-injurious behaviors and/or elopement, as a team discuss and develop and implement a safety plan. In addition, discuss the need for added supervision. As mentioned previously, behaviors are a form of communication, especially for the children who are nonverbal and/or have limited verbal output. Therefore, communication services should be discussed as a team to ensure that the student is able to have effective communication and/or access to various communication modes to afford them the opportunity to communicate. A parent may request an assistive technology evaluation to determine if the child needs access to an AT device to be able to communicate effectively. According to Florida statute, to receive an assistive technology assessment, that assessment must be completed within 60 school days after the team's recommendation. Please note that this 60-day timeline is independent of an initial evaluation. So even if a student already has an established 504 plan or even an IEP plan and they have already been through the initial evaluation process, this evaluation still holds a 60 school day timeline. Resources. There are various resources that are available to you, such as Individuals with Disabilities Education Act, rights law, the Florida Department of Education, and also Disability Rights Florida, which is our organization. And as mentioned, we are the state's protection advocacy agency. Our services are free and confidential, and we encourage you to explore our website to understand what services we may be able to offer you.
It's time for our 2022 Public Input Planning Survey. Your input matters to us. Please visit the link below between now and July 31st, 2021 to complete our annual Public Input Planning Survey. Your responses will help us plan our goals, priorities, and objectives for 2022. Please visit www.disabilityrightsflorida.org/survey.
This is the end of our presentation. Hopefully you've enjoyed and found all the information useful and helpful to you. We appreciate your time. Thank you.